Welcome back. Now, after 14 years of highly controversial amendments, South Africa's parliament has finally approved the Traditional Courts Bill. The bill now awaits the signature of the president to become law. However, the controversy has not yet gone away. We now speak to Anthony Diala, who is the director for the Center for Legal Integration in Africa at the University of the Western Cape. Mr. Diala, thank you so much for joining us this afternoon. Now, for those unfamiliar with the bill, please unpack what it seeks to achieve.
Thank you very much for having me. The bill has three purposes. The first one is to recognize the institution of traditional dispute resolution. In other words, resolution of disputes under customary law. The second objective is to regulate the structure and functioning of traditional courts in line with constitutional values. And finally, the last objective is a bit controversial. It seeks to enhance or to improve customary law and customs of communities. I'm not sure if communities want their customs to be improved or to be enhanced, but there you have it. These are the three primary goals of the bill.
Just unpack for us why you believe you don't, communities wouldn't want that to happen.
All right, thank you. So I don't know, government seeks to tries to improve the way people apply customary laws, but I'm not sure government has the authority. I'm not sure government should be interfering in the way people choose to apply their customary laws. So long as they are not committing any crimes, there are certain aspects of customs that are no longer suited to modern conditions. The patriarchal aspects are no longer suited to values of equality in our modern settings. When these customs emerged, they emerged in agricultural settings. People were living close together. The type of gender relations we had then are quite different from what we have today. And so that made the customs to be applicable to those societies. But apart from those patriarchal aspects of customs, I don't think government should be interfering in the way people choose to practice their customs.
Right. So traditional courts are supposed to be informal and based on African customary laws and as independent from state authority as possible. So are you then saying that this won't be the case?
Yes, definitely. There are certain provisions of that bill that sound warning bells as to the direction that the bill will take customary dispute resolution in South Africa. If I may just give two examples, I think it's section 17 of the bill that allows the magistrate courts to assist the presiding officers of traditional courts by sending an official to assist them in the way that they carry out their disputes resolution. And then there is, I think, section 18, immediately following on from section 17, speaks about record of proceedings. But in essence, this bill will import the English ways of resolving disputes into traditional justice resolution. And that is quite different, as many of us know. The ways that disputes are resolved under traditional systems, quite informal, seeks restorative justice based on Ubuntu and humanness, very, very informal. So the bill is definitely going to bring in Western systems of adjudication into traditional systems.
Speaking of those Western systems, what is the long-term impact on a society when it doesn't clearly define its own legal identity?
Very easy. The customs and traditions of the people ultimately disappear. Look at societies that experienced colonialism before the Europeans got to this part of the world. And sometimes we forget that Africa was the last place to be colonized by Western Europe. The Europeans colonized themselves first, then they were in the Americas, and then, well, of course, Australia, all those parts of the world, Asia, India, all those areas were first colonized before they came to this part of the world. And so, apart from Asia, the other parts of the world where the British and the rest of the European colonial powers went to the Spanish, etc., they ended up absorbing the indigenous people, their customs, absorbed them into the mainstream legal system, with the effect that only pockets of resistance, if I may use that phrase, small communities that continue to observe their indigenous laws, the rest embrace the common laws imposed by the colonizers. So if South Africa fails to take conscious steps to preserve the values of its indigenous laws, Most of the practices are disappearing under pressure from the Constitution. But if they fail to preserve the spirit, the values of their indigenous laws, they will ultimately disappear. That's what legal history tells us from other countries.
So then, Mr. Diala, how important is it then for South Africans to have their say in shaping such decisions when it comes to preserving our heritage?
Yeah, this is where consultation for passing legislation becomes very important. Bills are not just passed by Parliament. They go through several consultative processes, and that's where people have the opportunity to make inputs. You mentioned at the beginning of our discussion that the bill has taken 14 years to get to the stage. That's a long, long time, and it's because of the controversies that have trailed its passage. So it's up to the people to make inputs in the bill or to reject the bill entirely. Why couldn't the people come up and say, we don't need this bill, if really they wish to? But the traditional leaders are the ones who are mostly in support of it, because obviously perhaps it will enhance their powers, or for whatever reasons they were in support of the bill.
But why do you think that is the case with regards to how South Africans participate in putting together a bill such as this, that when then it comes into form, we then only want to question how it's been put together?
Yeah, great question. It all goes back to the legacies of colonialism. You see, we tend to look at colonialism in isolation, especially when we speak in the legal sphere. We look at only one aspect of it. Colonialism is a comprehensive process involving religion, the way we think, the food we eat, the culture, everything. So it's pretty comprehensive. And so I suppose that system of conditioning that started from long ago and has been passed down to our own generations affects the manner people receive such bills and their attitude towards the bill eventually.
All right. Thank you so much for that very insightful conversation with Mr. Anthony Diala, the Director for the Center for Legal Integration in Africa at the University of the Western Cape.